Our first speaker, first panelist this afternoon is Charles Murray. He is a social scientist and writer and is best known, of course, as the author of Losing Ground, the controversial analysis of the reforms of the 1960s. In 1986, Murray was named by the National Journal as one of the 150 people who make a difference in national policymaking. In 1988, when U.S. News and World Report published its cover story on the new American establishment, Murray was among the 32 men and women picked as those who dominate the intellectual debate on social policy. His latest book is called In Pursuit of Happiness and Good Government. It's being released next week, I understand, by Simon & Schuster. Charles Murray.
Thank you very much. When I got the notification that the topic was going to be the goals of punishment, my first reaction was that it was a fascinating topic, one of those that immediately made me think I wanted to speak on it and wanted to be part of the panel. And the problem has been that it has continued to be fascinating enough that even at this moment, I have not quite figured out what to say about it. The reason being that my first reaction was that I take for granted that punishment has a utilitarian function regarding crime. And I would be glad if anyone cares to dispute that, to go into the analyses which demonstrate it. But on the other hand, that's not very interesting to me. What is much more interesting to me about the goals of punishment are the things that punishment serves. I'm speaking of punishment in the legal system, that have nothing to do with reducing crime. Those of you who have read Losing Ground, and even those of you who will read, I hope, In Pursuit, find that I am enthralled by thought experiments as a way of getting at things. And what occurred to me immediately was a thought experiment regarding punishment. Suppose that, for example, we have a small white pill that we discover that when administered to a person convicted of a crime ensures that that person will never commit that crime again. Perfect rehabilitation. If he has committed a rape, he will never commit another rape. He may commit a robbery or a murder, but he will never commit another rape. Do you want punishment in such circumstances? And of course, if you think about that a little bit, the answer is very easy. Of course, you still want punishment because you need to deter the first occurrence of the crime. So punishment still serves a utilitarian crime reduction function there. Let's make the thought experiment a little more demanding. Let's say, suppose that we get another pill, which we can give to people when they are 1 week old or whatever, which has the effect of damping down their propensity to commit crimes to the level that we could achieve by any of the most severe forms of punishment and sanction and their deterrence effects. Suppose, in other words, I am saying that we have it within our power to produce a very low crime society which does not involve punishment at all, and further grant me, for purposes of argument, the proposition that nothing we add in the way of punishment is going to have any more such utilitarian effect. If that is the case, the question arises, do you want to live in a society which still has punishment? And my answer, again, instinctively at first is yes, I do. And let me try to spin out for you my own reasons for thinking that, and spin them out not as a person who is a specialist in crime or in the legal system, but one who has been thinking a good deal in the last few years about how human beings pursue happiness. The first point to be made is, I think, that the crime problem as we commonly construe it doesn't have as much to do with crime as we often think. I have been criticized for making that point, saying I don't give enough weight to being a victim of crime, and so I must immediately come back and point out I have been mugged at knife point in New York City, and I have been burglarized a couple of times, and I've had my car broken into 3 times. So I have experienced crime in our great American cities. But on the other hand, I don't think that a legal system in some fundamental sense of providing safety for us is judged just by the number of crimes that are committed. Rather, I think a very important function of the legal system and of punishment is what I would call lawfulness. And by lawfulness, I mean, to put it very simply, that we live in a society, if we live in a lawful society, we live in a society in which a person who physically harms or coerces or defrauds another person is sought by the police. If that person is apprehended, he is prosecuted, no matter what. Doesn't make any difference whether it's expensive to prosecute him. You don't do any plea bargain, you just prosecute him for that crime. And if the person is convicted, he receives a penalty. First-time offenders receive lighter penalties than multiple offenders, and people who commit less serious crimes receive lesser penalties than people who commit more serious crimes. But in a lawful society, that's the way that people who act in a predatory manner toward their neighbors are treated. And that a great deal of what distresses us about living in American society now is not the risk of being a victim of crime, but the perception that we do not any longer live in a lawful society. If one then puts the question, would I choose to live in a very low crime society, or which uses the white pills that I just described, or would I choose instead to live in a society which was lawful as I have just described it, knowing almost surely that the crime rate is going to be higher in that society, and perhaps much higher? I would choose the lawful society for two reasons. One is that if you take away my ability to commit bad acts, you have fundamentally interfered with my functioning as a human being. I think that if there is a thematic criticism I have of social policy in recent years, it has been this. We have tended to treat human lives as if they were segmentable. We have tended to treat the ways in which human beings seek to gain rewards and satisfactions and self-fulfillment as if you can separate them out. In the case of welfare policy, in which I've written extensively, the example is the way in which people talk about material resources. And they argue that what you want to do is have a guaranteed income, you provide everybody with adequate material resources to live a decent living, and then you let them go on to pursue self-esteem and self-fulfillment and the rest of it as they wish. To which my response is, no, it doesn't work that way. That for most of us, the ways in which we acquire self-esteem and self-respect and self-fulfillment is intimately tied up with the ways in which we go about acquiring material resources. Similarly, in the case of punishment, I suppose it could be argued that the white pills don't really infringe on your autonomy as a human being, because you're still free to go out and write great symphonies or great books or start great companies or be a great plumber. All that the white pills do is keep you from doing bad things. And I'm saying, no, it doesn't work that way either, that all of these things that we do in our lives are intimately bound up with our ability to act autonomously as moral beings, in which case we have to have the option of doing something bad. And if you chemically take away that option from me, you have put me in a less good world than I live in now. However, I would try to move beyond that statement, which is very abstract, I think, in many ways, to another reason why a lawful system, which includes punishment, is essential to the pursuit of happiness, as I am using the phrase. And that has to do with a term that has become extremely fashionable recently called community. I'm a little bit bothered by how fashionable community has become, because I have just written a book which also treats the concept at some length, and I hate to consider that I am in the middle of the trend, and I may very well be. I would quickly add that a great many people are misusing the term community. But a community, again, does not exist because people say it exists. It is not a geographic entity. It is not something which exists because of being dubbed. A community is rich and vital and rewarding for the members of the people who live in that community insofar as it fills functions, important functions in people's lives. Take away those functions, and the community becomes a bedroom community out in the suburbs in which people live in proximity to each other and don't have any other connections beyond maybe having a cup of coffee together once in a while. If you want a community that is a fulfilling community, you've got to give that community something to do. And it seems to me that one of the most important primitive things that communities do, and one of the reasons why communities form in the first place, is as a way of identifying the good folks who are fighting off the outlaws. That an important source of the glue of communities consists of the process of coming to an agreement about the ways in which moral people ought to live in proximity to one another, and saying of predatory people, what you have done is wrong. It's not just inconvenient. It's not just physically hurtful. It's not just something we want you not to do in the future. It is more fundamental than that. You are an outlaw and are not one of us as long as you continue to behave in that way. And because what you have done is wrong, we validate it being wrong by our system of justice and by the fact that you are punished. And to take away that seems to me fundamentally also to take away an important source of the way of the satisfactions in human lives, and an important mechanism whereby we work out this very complicated thing called being a human being in the midst of a community. Somehow I suspect that this kind of meditation is not what I certainly had in mind to give when I was invited, and I hope that the other two panelists will bring us back to what I think are some very important and more practical themes about the goals of punishment. Nonetheless, let me suggest that crime has very little to do with it in the senses I have just talked about, even though punishment has very much to do with crime in other senses, and that a crime-free and also punishment-free society, it's not so much a matter of whether it is humane or inhumane, but that it would be fundamentally inhuman. Thank you very much.
Charles stayed well within his allotted 15 minutes, and I would mention to the other two that we'll keep it to 10 to 15 minutes each to start here and then have the opportunity for interaction. I'll just make one observation quickly. I have a dear friend who has recently spent many years on the inside of the criminal justice system working in jails, and she began that service as a committed, dedicated liberal, and still regards herself, I suppose, as a liberal, but in a long conversation recently, repeatedly had observations quite a bit like what you just offered. And she said, "Does that mean I'm a conservative now?" And my response to her was, "Well, I don't know, but you're a different person than you were a few years ago." And I think that that is one of the things I've learned in 8 years of research in this area, and particularly my 5 years in research in the criminal justice area, is that sometimes you get surprised at the sources of commonality that you stumble across as you attend conferences and, more importantly, actually work with people in the bowels of the system. Now, that is sort of a prelude to my introduction of Barry Ivan Slotnick. He is a criminal defense lawyer who, as he has said it, hates to lose. During his 26-year legal career, he has apparently won 95% of the cases he has represented, including one 12-year stretch where multiple sources indicate he never lost a case. Now, Rudy Giuliani, whom many of us here know, the U.S. Attorney for New York's Southern District, agrees with the virtually universal praise for Slotnick's incredible courtroom ability, but he also says this: "I respect Barry Slotnick. He is a good lawyer and an honorable person. I have always seen him keep his word." Mr. Slotnick has a BA degree from the City College of the City University of New York, an LLB from New York University. He was admitted to the bar in New York in 1961 and before the U.S. Supreme Court in 1966. I did a lot of reading. He describes himself as a Republican and a conservative, and indeed in one of his articles I came across a comment that sounds an awful lot like me. He said, quote, "The disease contaminating our jurisprudential system is violent street crime." Please join me in welcoming Barry Slotnick.
I think I can take much less than 15 minutes and perhaps be much shorter if Charles brought his white pills. I would be doing lots of real estate work if Charles were able to perfect his white pills. And even though the American Civil Liberties Union would start an action against us, I would distribute the white pills. But unfortunately, there are no white pills. I have not heard the word punishment, and it was interesting when my secretary spoke to me and we did a bit of a debriefing about today's topic. I looked at her and I scratched my head and I said, you know, I haven't heard the word punishment in a courtroom in 20 years. And she looked at me and she said, well, what about all the people that are getting sentenced? I said, they're being sentenced for reasons other than punishment. They're being sentenced because judges are afraid to use the word punishment. So they say, well, Mr. Slotnick, heaven forbid one of those people to be sentenced as my client. It's necessary to send a message out to the community, and they call that deterrence. Or your client really isn't a bad chap, but perhaps he might have a thought about committing a crime again, so therefore we're going to rehabilitate him. No one talks about punishment. The people of this country speak about punishment, and they are wondering what the judiciary is talking about when they send messages out to the community, because the community is quite aware of the messages. I mean, the messages are very simple. If you're a drug dealer and you're convicted, you're going to go to jail for double digits, and there's no question about that. And that's because it's to deter others in the community not to do it, and it's to rehabilitate you. It has absolutely nothing to do with punishment. Well, I fear that we're really avoiding the issue, and perhaps this panel is one that's much needed. As a criminal defense lawyer, strange as it may sound, I believe in punishment. I think that one of the reasons that the crime rate in this country has skyrocketed, and I take the former Attorney General's statistic as being correct, 100% in the last 12 years or so, is because people are not getting punished. They're either being rehabilitated or they're being used as a deterrence factor. So I think we ought to send a message out to the community that there is punishment for those that commit crimes. Now, the problem that I have about punishment is that my clients should not be punished. And we'll talk about some of my clients and what has happened with regard to punishment. While Rudy Giuliani may say nice things about me in public documents or personally, and I may say nice things about him and to him privately, we disagree on the role of punishment. Because I know one thing, if the United States Attorney for the Southern District of New York were asked, he would tell you that he believes in punishment. However, he believes in punishment for people who trade on inside information. I'm not too sure I agree with that, at least not the extent of the punishment that he believes in. He believes in punishment for people who are wearing white collars, the colloquial white-collar criminals, and again, I'm not too sure that I believe in punishment for people who are wearing white collars. I think that Congress has seen to it that there is great punishment for white-collar criminals. On the plane coming over here, I read some astounding article on RICO forfeitures and fines that are being contemplated, and I think that that is punishment for white-collar criminals. I think punishment clearly, without a doubt, and as I said before, with regard to drug dealers, rapists, robbers, violent criminals, which should really be our first essential concern. They should be our first essential concern. I think the message should go out to those people that if you're caught, you're going to be punished. We need not send any greater message to the community than that. I don't believe in rehabilitation because it simply doesn't work, and not because human beings can't be rehabilitated, because a small percentage are. It doesn't work because our prisons are places where crimes are being perpetuated and people are being taught the better efforts of crimes. Furman against Georgia in 1972 was a marvelous case. It was an important case. It recognized that punishment could not be doled out on a discriminatory basis, on a racially discriminatory basis. The class of 1972 was a group of people who were released to the outside world from death row. And a study has been done. What happened to those 40 or so people that were released from death row? Well, 3/4 of them have apparently lived the legitimate life. 3/4 of them have gone back to their families and haven't robbed and mugged and raped and killed again. And someone brought that up to me and they said, well, that's a pretty good reason for not having the death penalty. And I said to them, no. I said, the reason that 3/4 of those people have not gone out to murder other people or to do great injury, great physical injury to our society is because they were on death row. Because they sat in a cell for 23 hours a day knowing that any day now, unless the Supreme Court decided their way, any day now they were going to be either strapped in a chair or go through some other barbaric means of ending their life. I said that was sufficient to send a message to them, and that's why they have become, quote unquote, rehabilitated. I wait to find what the statistic will be 10 years from now with regard to those who have been charged with similar crimes, who don't go to death row, but go to prisons. I fear that 75% of them become recidivists, and that's basically what the problem is. So we need punishment. We need society to send a message out to the criminals that we are not kidding and that we are very serious. We need to obey the mandates of the Eighth Amendment because, as the Supreme Court has said, we cannot condone arbitrary or freakish types of penalty because that violates the Eighth Amendment. We need to know that there are procedural safeguards. It's very, very important. But we are now afflicted. It was marvelous when I graduated law school, and I don't know, it was an early date in the 60s. Some of you were born about that time. When I graduated law school and I spent my first year as a criminal defense lawyer, I could look at a police officer and say, your shoes are dirty, and the judge would say, oh, that's terrible. Obviously, that violates some tenet of the Constitution. You're right, counselor, case dismissed. Well, while I was doing all of those marvelous things in a courtroom, and while I was suppressing everything that I could possibly suppress, and while we went to the Second Circuit on one of the first electronic surveillance cases to find Judge Kaufman write a decision about how draconian it was, and while all of the people that were being represented were getting off on so-called technicalities, what I didn't see, and I would have done it anyhow, but what I didn't see was that crime was growing right under my feet, that these decisions were planting seeds along the way. Please don't tell the other members of the Criminal Bar Association I'm saying these things. The seeds of crime were steadily being planted. I found out something this year because we've had a problem in New York. It's a terrible drought, that weeds are much stronger than refined grass. That once weeds take over, they spread, and there's only one way to get rid of weeds, and you've got to spray them with some toxic substance. Well, I suggest that one way we get rid of criminality in this society that is totally racked with criminality is to start spraying those who are involved in the criminality with some toxic substances. I have asked the governor of my state to sign a bill that goes on his desk every year calling for the death penalty. Of course, he does not do that, and I'm not sure on what grounds. And unfortunately, I will tell you now that the mandate of the legislature, which could override his veto, doesn't occur because they're just too afraid. I spoke to Senator D'Amato when he proposed his death penalty bill with regard to shooting of police officers, which finally, I understand yesterday, finally has come to a vote, or the day before, and it looks like it will become law. I asked him to extend it to deal with those that are involved in general narcotics trade, and he said, Barry, you must be crazy. I've got enough difficulty trying to get this death penalty bill through. So basically what's happening is we're taking a reverse step. While when I first became a criminal defense lawyer, it was clear that people were getting out on technicalities. We're now taking a reverse step because we have to eradicate the weeds. And I suggest very strongly, and I obviously would not say this to a judge at sentencing, but I suggest strongly as a private citizen and someone who's been part of this criminal justice system, that the only way to deal with it is to really look at punishment. And when we have a panel that talks about the goals of punishment, you only hear it on panels. Judges should have discretion to impose proper sentences within limits, including punishment. Judges should have that discretion. Congress has seen fit to take it away from them by enacting a reform sentencing law, which is being found unconstitutional in every place that we go to. And it's being found unconstitutional not for the reasons given, but for the simple fact that the judiciary is very annoyed that Congress has taken away their discretionary powers. While I believe in punishment, I also believe in discretion. And as I come to a close, I wish to remind you that, again, what I had to say is that not all criminals deserve punishment. Not all criminals deserve to mandate of jail because of deterrence, because I'm a big believer of not sending people to jail. And not all criminals deserve the fact that they're going to be rehabilitated because they don't have to be. Having, as most of you know, just vacated the sentence delivered to one Bernard Goetz, a young lad, an electrical engineer who stood on a subway surrounded by 4 thugs and probably saved himself some severe injury properly under the law as a jury found it. He was sent to jail because as the judge looked at him and said, I've got to send a message out to the community. Well, I wasn't sure what message he was sending out to him. You can't do this again. Well, I would hope he would never be found in that position where he would have to do it again. And carrying a gun in New York is illegal, and someday perhaps that'll change. In fact, I'm sure someday that'll change. But when you deal with a Bernard Goetz, there is no reason for him to go to jail because he doesn't deserve punishment. So each case has to be reviewed and looked at simply in its own factors. There cannot be a general statement. You cannot take discretion, and those of you who have some congressional influence or who know where the hill is, tell the guys up there and the women up there that you can't take discretion away from judges because different people may commit the same crime. And you know what? We must treat individual defendants as being uniquely individual. So while Bernard Goetz was sent to jail and a court has seen fit to eradicate that sentence, you have a fellow in this town by the name of Rowan, who is not exactly my best friend, but I don't think he should go to jail either. There are lots of people who carry weapons and use them that should go to jail and be punished for it. If I've said anything, what I've tried to say is that the judges understand the mandates and the needs of the people, sometimes better than Congress. Don't take their discretion away and understand that punishment is a uniquely important part of the system because it may give us some peace in the streets and it may put us at rest and it may put some terrible people in jail for the right reason. Thank you.
Our third panelist this afternoon is Dr. Ernest von Haag. He is presently Distinguished Scholar at the Heritage Foundation. He's a member of the Council on Foreign Relations, and is former president of the Philadelphia Society. He is the author of many books, including 3 of particular interest to us on this panel: Political Violence and Civil Disobedience, 1972, Punishing Criminals, in 1975, and The Death Penalty, a Debate, in 1983. His curriculum vitae goes on for several pages, so in keeping with a promise I made to him at the time he accepted, I won't read the whole thing. Dr. Ernest von den Haag.
According to tradition, punishment has 4 purposes: rehabilitation, incapacitation, retribution, and deterrence. These purposes call for inconsistent policies, which courts and penal institutions must try to combine as best they can. Incapacitation and rehabilitation address the individual offender. The individual offender is deactivated and kept from further offenses. If they are not replaced, even if the individual offenders are not replaced, this deactivation also reduces the crime rate. Replacement is unlikely if the offenses were idiosyncratic. Incapacitating the Boston Strangler reduces strangling in Boston. Deactivation also reduces the crime rate when offenders need not sell the proceeds of their crime. Stolen currency need not be sold, and there is no market for the proceeds of rape. However, when it comes to most property crimes, deactivation is unlikely to reduce the crime rate at all. Stolen cars, TV sets, jewels, furs, hijacked trucks and their cargo, all must be sold if the offender is to realize his gain. When criminals are deactivated, fewer stolen goods come on the market. This raises their prices and makes stealing more profitable. As stealing becomes more profitable, new offenders are attracted until, owing to their activity, the price of stolen goods falls to the old level, attracting the previous number of offenders. Thus, except in the very short run, the rate of property crimes remains unchanged, however many offenders of this kind you deactivate. Deactivation merely replaces one offender with another. Mr. Smith now will burglarize you instead of Mr. Jones, who is in prison or being rehabilitated. It won't make much difference to you, and Mr. Jones is as well qualified as a burglar as Mr. Smith was. The effect of deactivating those convicted of market-dependent crimes, which is most property crimes, does not differ from the effect of deactivating prostitutes, or for that matter, lawyers. If enough prostitutes or lawyers, or for that matter, salesmen or farmers, are incapacitated or rehabilitated, the price of their services rises. As rendering these services becomes more profitable, new practitioners are attracted until the old rate of supply and price is reestablished. To be sure, not everybody can or will serve as a prostitute or lawyer. But if the price is right, enough persons become available, the potential supply is infinite in practice. The old rate of service will be reestablished quite soon with prostitution, which requires no license, and it will take a little longer time with law because it does require a license. Deactivation and punishment, of course, occur simultaneously through incarceration mostly, and therefore many people confuse the two things. But they're different. Punishment has important effects beyond deactivation, such as retributive justice and deterrence. Retribution, also known as justice, addresses not the individual offender so much as through him the community at large. Now, I must admit that much of what I wanted to say about justice has already been said by my friend Charles Murray, who, as he often has done before, has engaged in anticipatory plagiarism. But, there's not much we can do about that, so I will go on. Doing justice is the only one of the four purposes of punishment which is an end in itself. Justice produces moral satisfaction, nothing more and nothing less. All other effects of justice are purely incidental. That is, justice has no instrumental purpose. We do justice by punishing offenders in proportion to their culpability and to the gravity of their crimes. However, neither proportion could be established objectively, even if gravity or culpability could be. We have no way of knowing how much punishment is proportionate to the gravity, however established, of any crime, or to the culpability of any criminal. As to gravity and culpability themselves, we feel that more of either deserves more punishment, but we cannot fathom how much more. Some crimes obviously are worse than others, although we cannot specify how much worse. Even if we could, the weight to be given respectively to culpability and gravity in determining the deserved punishment would still be arbitrary. So, therefore, is the punishment. Actually, and in practice, punishments are legislated according to traditional classifications without an objective basis which would permit us to demonstrate their justice. Yet, capital punishment for parking violations would be felt to be unjust, however effective. And a fine for murder, say a $5 fine or probation, would be equally felt to be injustice. The traditional sense of justice tells us something, even though it cannot tell us whether 5 years for a burglary is more just than 2, and whether 5 years for manslaughter is more just than 10. If the law is to have the social support it needs, punishment must satisfy the sense of justice as it prevails in the community. Crime has a moral dimension, requiring proportionate retribution as a moral response. The popular rejection of treating crime merely as a disease, to me, makes a lot of sense. And the medical model of corrections is wrong precisely because it omits the moral dimension. Nobody volunteers for diseases, since they are painful or disabling or disfiguring or life-threatening. However, criminals volunteer for crime because the undesired effects are not experienced by them but by their victims. Crimes are attractive, and they are morally wrong. Diseases are neither. Therefore, diseases should be treated, but crimes must be punished, otherwise they become too alluring. Let me diverge for a moment. If we assume criminals are not responsible for crimes because they lack freedom of the will, we may as well assume that judges and legislators are not responsible for punishment because they too lack freedom of the will. Both are conditioned by genes and by their environment. Criminals are not responsible for crimes, and judges are not responsible for punishments. So that leads us absolutely nowhere, of course. If we hold that only criminals are not responsible for crimes, whereas judges and legislators are responsible for punishments, then we have somehow to explain why criminals belong in this irresponsible class and other people do not. And to my knowledge, that cannot be done unless you can show this a particular criminal under the law is not responsible. In other words, you cannot base yourself on philosophical notions about freedom of the will. One other point I wish to make, and I'm sure that Mr. Slotnick will not like it, but I will make it anyway. A punishment regarded as disproportionately severe or lenient is felt to be unjust. But however disproportionate to the crime, no punishment is ever unjust to the criminal. If his punishment has been imposed according to established legal rules, and if he is guilty, the convict is in the situation of a gambler who lost. Anyone who gambles or engages in crime volunteers for the risk of losing, that is, of being punished in the case of a crime. If he loses his fortune or goes to prison, he cannot reasonably complain, however great the loss or disproportionate the punishment. He volunteered for the risk, and he knew the rules. A community properly might oppose punishment it feels to be disproportionate to the crime punished. But disproportionate punishments are disproportionate to crimes, not to those who commit them. They volunteered the risk to risk the punishments, just or unjust. Only an innocent can be punished unjustly. He did not commit a crime, by definition, and therefore, by definition, did not volunteer for the risk of being punished. Let me turn now to deterrence. As does justice, it addresses a community by means of the individual offender. When punishment is threatened, and when the threat is carried out against those not deterred by it, it becomes credible and deters others. Threatening punishment controls crime then, provided the threat is severe enough and carried out often enough. However, no criminal justice system can punish every crime, and even most crimes. Therefore, criminals risk not the threatened punishment, which we may regard as a list price, but that punishment divided by its frequency. If an offender is convicted every 10th time he commits his crime, a 10-year prison sentence amounts to a 1-year sentence per crime. The discount on the list price varies, of course, from offender to offender. If one commits only one crime and is caught and convicted, one may pay the full list price. But one who commits many crimes usually benefits from a quantity discount. He is likely to be caught, but unlikely to be caught each time. To be effective, punishment on the average, of course, must deter more than crimes attract. Could you get me just a little bit of water? Since the attractiveness of crimes to different persons differs, thank you, and the threatened punishment is uniform, the punishments will be more severe than is needed for deterrence for some people, and less severe than is needed to deter others. Still, the lower the level of the legal risk, the higher the crime rate. Let me quote from Bernstein and Wilson, Crime and Human Nature. Between 1962 and 1973, the probability of imprisonment for an index crime fell fivefold. No wonder then that in that period the crime rate increased more than doubled. It's as simple as that. We do not really need to look for many far-fetched social explanations. When punishment decreases, crime rises. It's as simple as that. Crime is reduced then by increasing punishment. From this we can pretty well establish what the proper punishment for any crime should be from the deterrence viewpoint, which has to be modified in the light of justice. The proper punishment for each kind of crime depends on how much of the crime the community will tolerate, rather than to bear the moral and material cost of increasing punishment. The punishment the community imposes depends on that cost and how much of it is willing to bear. Parking violations could be reduced by doubling the fine and or the probability of having to pay it. If the community feels that the expected reduction of violations is worth the cost, moral and material, of increasing the punishment will be increased. But quite often the community is willing to tolerate a somewhat higher crime rate rather than to increase the punishment. Just one more point. I think I have only a few more minutes. Legal threats are addressed to all who would violate the law, but the burden falls mostly on those most heavily tempted to do so. The poor violate the law more often than the rich, because the rich, by virtue of being rich, are less often tempted to do so. Anatole France's famous saying, "The law in its majestic equality forbids rich and poor alike to steal bread," accurately describes the criminal law. Although its prohibitions are addressed to all, many actions it prohibits are attractive only to the poor, like stealing bread. But yet the sarcasm seems to me rather silly. The law always prohibits everybody from doing what only some are tempted to do, be it murder, insider trading, or stealing bread. Although the prohibition law was addressed to all, its burden fell only on drinkers. Laws would be redundant if they prohibited only what nobody is tempted to do. Yet temptation is always unequally distributed among persons and classes, and we cannot really predict who will yield to it. Some assert that the capitalist system first victimizes the poor and then punishes them for the crimes produced by their victimization. Yet no social order, capitalist or socialist, can avoid inequalities of power, prestige, and income. They imply that some people are most advantaged, and we call them the rich, and others are least advantaged, and we call them the poor. The least advantaged always are most tempted to commit crimes because they have most to gain and least to lose. Yet they are not compelled, and most of them do not commit crimes. Indeed, rich and poor can be restrained by legal disincentives. The poverty environment, no more than the wealth environment, exonerates from responsibility those who do not resist its temptations. Well, I have 2 more minutes. Okay. All right. I just want to say a word about the effectiveness of deterrence. People respond to incentives and disincentives offered by natural, social, and legal laws. Natural laws are self-enforcing. Few persons jump from the 60th floor of a skyscraper, although it's much faster than the elevator, for obvious reasons. Economic laws are almost as self-enforcing. Attendance at this conference would be much higher if every second attendee were awarded $10,000, and much lower if he were fined $10,000. Given moral inhibitions and other circumstances, a chance of $10,000 of a $10,000 reward attracts to conferences and to crimes, and the risk of a $10,000 penalty deters from either. However, punishments are administered through police and the courts and are necessarily less certain and less than the impersonal disincentives of economic, let alone natural law. Therefore, threatened punishments deter less effectively, and in contrast to my colleague, Mr. Slotnick, I am in favor of punishment, of making punishment as independent as possible from the individuality of the offender, of the judge, and of the crime, as clearly automatic as justice permits. There is an issue which we can discuss. One other thing. Some psychologists and criminologists, sociologists, believe that deterrence requires rational calculations by prospective criminals, which of course are rare. But this is not so at all. When a physicist predicts the behavior of a moving body, or when one predicts the behavior of prospective criminals confronted with incentives and disincentives, no calculation by the moving body or by the prospective criminal is assumed. The prediction of behavior requires calculation, but the behavior predicted does not. Observation alone shows that people respond to incentives and disincentives by forming habits accordingly. Rewards attract and punishments deter. If we want to reduce crime, we must credibly threaten punishments sufficient to deter it. Thank you.
Well, I think that at 2 points in Dr. von den Haag's remarks, we got to the nub of a point that I had already made a note myself to raise as the first question. And that's the one advantage of being the moderator. You can't really jump in on the debate, but you get to ask a good opening question. And I'll do that, and then we'll start to take it from the audience. And from now on, we'll just stay at in our chairs here to conduct the rest of this. And it's for Barry. It's this. I would disagree with one assertion you made. I think the sentencing guidelines in the circuit opinion, I cannot speak to the district court opinions, the various ones, but the circuit court opinion, the reason the sentencing guidelines were found unconstitutional is because they came from a body with mixed powers. Having said that, I'd go on to get to the question of determinate versus indeterminate sentencing. Law is inevitably arbitrary, but reducing arbitrariness seems to be as worthy a goal as any imaginable in the criminal justice system. And that's why I was struck by so many of your comments sounding very reasonable, given the perspective you started from. I say that in all friendliness. I'm not being, but that point did not. It didn't register with me, and I'd like you to elaborate a little bit on why you think an indeterminate structure, subject to the individual whim of the jurist, is preferable to a determinate one like we went towards with the Comprehensive Crime Control Act in '84.
First comment, the circuit court opinion would have found the Sentencing Act unconstitutional had it come from a homogeneous panel. I think that the real reason was something that would not be expressed by anybody in the judiciary is that the Sentencing Reform Act very simply took away the powers of discretion from the judiciary, and you're not going to get a body of judges to say that. So that I think what I did say was that quite clearly the courts will find this to be unconstitutional for the simple reason that they do not like their powers infringed upon, but will not express that. Why am I not in favor of determinate sentencing? Because I think it's just terribly unfair. With all due deference to Professor Vandenhaeg, I don't think that we are scientists. I think rather those of us in the criminal justice system are artists, and we've got to deal with each individual problem on a very specific mode. When someone desires to step off a ledge because he wants to beat the elevator down, he knows at the end of the road there is no life. When someone commits a crime, there are a variety of reasons as to why he commits the crime and who he is in committing the crime. There's no scientific certainty, whereas there is a scientific certainty with regard to beating the elevator. So that a judge has to take into consideration who that individual is. Now, determinate sentencing takes away from the judge that ability. And that's something that's very dangerous. I think individuals have got to be treated as individuals, because we all are. A person like Bernhard Goetz, for example, if I may, who carries a gun allegedly illegally, because that's now being reviewed by the Court of Appeals, and is told that he must go to jail for 6 months, he must be on probation for 5 years, he's got to pay restitution and do community service, is ludicrous. Whereas another individual who is arrested merely for carrying a gun, but not having used it, and understand that Goetz used the gun, but it was acquitted for its use. Another individual who was arrested carrying a gun, who has a record of robbing 5 gas stations, I think has to be treated quite differently than a Bernhard Goetz. Quite clearly, individuals have got to be looked at differently. And you cannot, and the new guidelines are draconian, you cannot just put people in numbers. You know, he's a number 17, so he goes to jail for 3 1/3 years, less 1/6, or he's a number 27, therefore he would go to jail for 15 years. People are very different. People do definitive criminal acts for various reasons. And therefore, you've got to look at that individual. In New York State, the crime of murder carries with it 15 years at a minimum to life. Now, there are Jean Harris. I don't know if all of you know who Jean Harris is. Scarsdale diet doctor case. Was convicted of that crime, and she went to jail for 15 to life. I'm sure the judge would have given her probation if he wasn't concerned about the public outcry, but he just couldn't. He gave her 15 to life. That was an absolute and total injustice. Clearly, there are other people who have gotten the maximum of 25 to life who well deserve it. So you can't mix human beings. We're not dealing with a scientific circumstance. We're not in a casino whereby a gambler knows that he's going to put his chips up on the table and he only has $500 and that's the most he can lose. We're dealing in a circumstance where there are a lot of variables. Unfortunately, one of the variables is that some people are acquitted for the same crimes that others are convicted of. Some people are convicted who should never be convicted. Some people are convicted who have committed the same crimes definitively, but have lesser culpability. You know, one can commit murder by walking into a bedroom and finding their fiancé entangled sexually with someone else and shooting both of them and do 15 to life. Whereas the same person who walks in to a gas station and blows away the gas station attendant goes to jail for 15 to life. I just feel that to be unfair, unjust, and inappropriate. And I do trust the judiciary.
We'll let Dr. Vandenhaeg respond, and then Manuel, go ahead and ask the first question afterwards.
I do agree we are not scientists, but I don't. Doesn't work.
Better that way.
Yeah. Perhaps. Hello? Yes, does it work? No, not yet.
Yes.
All right. I feel that we are not scientists, but with the exception of Mr. Slotnick, perhaps we are not artists either. Of course, it would be ideal if each criminal could be treated according to his individuality. But in practice, what it means is that each criminal is treated according to the individuality of the judge. That is, if Mr. Slotnick and I were to sit in judgment about the same criminal having committed the same crime, we would probably impose very different punishments. It seems to me that when you commit a crime, you should take the risk which the law should clearly enunciate. You should not be able to say, well, I was in a fit of jealousy about my fiancée. I don't really see why it is worse to hold up a gas station than to kill your fiancée's lover and herself. One involves some sort of interest in material property, the other involves some sort of interest in sexual property. I don't see the difference. I don't see why one is better than the other. But I'm not going to defend the Caesars. I'm merely pointing out that if I am the judge, or Mr. Slotnick is the judge, the results would be very different. And that's precisely why I think the law should prescribe the results. The judge should not be able to express his individuality by his sentencing policy. And the criminal's individuality is his business, but not the business of the law.
I'm going to be arbitrary and rule that we don't want to preempt too much of the following panel, so we'll go ahead and let Manuel rather than a response from Barry.
Thanks, Pat. Well, I'd like to address the question to Ernest, Dr. Van den Haag, in connection with the objection you voiced earlier. In the midst of a talk, which I agree with virtually all of your comments, but you made the point that if there is a law that's passed and advance notice is given of the severity of the offense, $1 million, or, for example, the penalty for a company that comes out with a new effective drug but does not clear it with the FDA, and the penalty in advance, again, clearly $1 million for the introduction of that drug without FDA approval, rather harsh result. And it seems to me desirable that the criminal justice system should allow not merely third parties, but also the criminal who violated such a law in advance to have standing to raise objections based on disproportionality or cruel and unusual punishment. Do you agree?
I have no objection to the criminal raising whatever objection he wishes to raise against the law. But my point was very simple. However unjust the law was, he knew that that is what the law would impose on him. He volunteered to take that risk, and that's that. Now, he can oppose the law. You would oppose it. I would oppose it too. And it is not an invitation to tyranny, because I certainly think that the community should oppose the same laws that you and I would oppose. I merely said the criminal knew that that was the law. Can't complain about injustice.
Your turn over here.
A question for Dr. Murray. I take it that your bottom line is that you would not administer or use either of these white pills because it would infringe on personal autonomy and thus would be inhuman. So it seems, therefore, that the reason for punishment, ultimately, bottom line, in your opinion, is that Dr. Van den Haag expressed, which is the moral outrage and the need for moral satisfaction and the sort of retribution. And if that's right, I'm wondering, first of all, from whence that comes, which is obviously an epistemological question, but more importantly, how would you use, or to what principles would you look in determining what the appropriate punishment is to satisfy that sense of sort of moral outrage?
A couple of points. One is, as I thought about this thought experiment, and I should emphasize the reason I like thought experiments is not because I think they drive everyone to agree with me, because I think they provide an interesting springboard. And in this case, for example, I would have no problems whatsoever with compelling a convicted criminal to take the white pill. because it is true that I think it diminishes his humanity in a very important way, but that is also, having committed a murder, a punishment which I think is okay. But I have a very strong distinction I would make between making him take the white pill after the crime and making everybody take it when they're 1 week old.
Which white pill?
The one that keeps you from ever committing a crime again after you've already committed one. So that would be a punishment which I would find perfectly acceptable. I don't think that I am talking about, in terms of whence the punishments come, about anything which is at all unusual in terms of the people in this room. I have, I guess, one thing that would distinguish me from some of you, which is that I would have a very short list of things which are prohibited. I would have my crimes consist of those things which consist of physical harm, physical coercion, fraud, basically. Those are the kinds of things which I think should be against the law and which are predatory behavior. So in that sense, I have a certain kind of stance that I take toward what should be prohibited. But in terms of what the punishment should be, I think I'm associating myself with what Ernest was getting at, which is that the community comes up with a sense of what's appropriate. And you do not have to agree with every jot and tittle of the punishments which are prescribed if indeed you live in a community where this process has been gone through and there is a consensus on what constitutes appropriate and inappropriate punishment.
I guess what's the source? There's ultimate law, which is reflected imperfectly perhaps, but reflected in the Constitution. And then there's the area of democratic choice, and I think that's why,
what I was really getting at.
Right, some of us part company with Barry's formulation about judicial discretion. We'll go to this side and then come back to you.
I have a question for Mr. Slotnick. I first of all thought your arguments for Ms. Harris and Mr. Getz were extremely persuasive, and God help me, I even admit that your argument for Mr. Rowan was persuasive to me. But I agree that you're correct that there's individual injustices. However, that person has been found guilty by the justice system, which mortals have set up until we have nothing better to set up, in a sense. I've seen a judge, being an inner city prosecutor, too many times, a human being sitting up on that bench, looking at a pre-sentence investigation which clearly indicates that this person is, in your expression, a weed. And I've seen this individual human being sitting up on that bench is simply unable to perform his or her duty as a judge, rather than just a human being, as a judge following the law, to sentence this weed. Now, you mentioned earlier, we want to bring out the concept of punishment, and then you ended your speech by stressing the concept of the individual. You've done an excellent job of raising the questions. You've got extensive experience with the criminal justice system. Do you have any way or any philosophy that we can resolve that tension? Because when a judge is unable to perform his or her duty, a lot of people down the road are going to suffer because somebody didn't get the 25 to life and instead got paper or perhaps got a 10-year suspended sentence.
In New York, we had a judge who flipped a coin. He does not sit as a judge anymore. I think that one of the things that's extremely important for us to recognize, and again, we are all artists, we really are, is that the punishment has to not only fit the crime, but also the individual. Now, the judges and the good professor and I might not be far apart if we both sat in black robes sentencing individuals, because there are other people that would guide us. There is a probation report. There is a defense lawyer. There is a prosecutor. There is a victim impact statement, which most states accept. There is the local media, which now has become very active in our courtrooms, especially by putting cameras in our courtrooms. There are professionals, and most of all, there are appellate courts, and I think one of the things that unanimously should occur within these states of our republic is that the appellate court should be able to review all sentences either way. And that's on the way and happening. So I think that the good professor and I would not be very far apart in terms of our sentencing. And I really believe that we would sentence the same individuals who committed the same crimes reasonably similarly. It's unfortunate that you may have had a judge or several judges who fall into the category of so-called bleeding hearts or fascists, depending upon which side you're on and depending upon who they are. But they ought to be reviewed. I mean, judges should not be the final say. They should be reviewed by other judges, and they ought to be guided. In the Eastern District of New York, for each sentencing, there are a panel of 3 judges who sit around and make a suggestion as to what a proper and appropriate sentence would be. Equality in sentencing, I think, is wrong because it denies the individual proper justice who's standing before it. And I think that can be resolved by the experts in the area.
Yeah, I guess I tend to think that right now, with the new sentencing guidelines, are probably good in reducing discretion. But as to the question of discretion in general, in sentencing, aren't we, instead of talking about the individuality of the individuals, talking about the individuality of the crimes? That is, that the legislature goes and passes in its rather awkward fashion a specific law that makes illegal a category of crimes: carrying a gun, an unregistered gun, taking the life of another individual, and that the individual crime, shooting your fiance in sexual conduct with somebody else versus walking in cold blood to a gas station and blowing away a gas station attendant, are actually different. So doesn't that address then Dr. Vandenhaeg's point that it's really more in relation to justice fitting, the sentence fitting the crime as opposed to the individual?
Absolutely. However, the problem that I face is that there's also another ingredient in the sentencing process, which is the individual. And sentences should also fit individuals. I have no problem with the legislature when they say for a crime of bribery, the sentence can be between probation and 15 years. You now have given the judge a broad range, and he will decide exactly who and what he should treat and how he should treat it. I have a problem when the legislature says for the crime of bribery, if it's over $6,000, $500, or whatever it is, the sentence must be X. Or if they give the judge a 2-year parameter between 5 and 7 years, I have a problem with that.
Barry, the question I have is you seem not to have a problem with the criminal justice equivalent of forum shopping, that it becomes a matter of that range you just gave from probation to 15 years. It'll depend on which judge you happen to get by either the luck of the draw or by filing before a certain judge quickly, or by just whatever factor determines the judge winds up determining the sentence to some extent.
Unfortunately, we're not administered by robots or computers, so it's not all going to work out the same. There are injustices that occur in the system, and perhaps I would rule in favor of the individual. Yes, there is no question. If we can forum shop, I would be the first one to go to Pathmark versus A&P because the prices are cheaper. It doesn't always work that way, and unfortunately there are judges who are beyond the Celt or beyond the propriety of one side or another. They've taken a side. Well, those judges are being looked at. They don't get reelected in the federal system. They're put on for life, and you know what? I've watched judges. Something happens to them after a period of time. They come down to the appropriate means. I trust them. They're individuals. Those that are elected are even more trustworthy. Those that serve for life, it just takes their experience, and eventually they meet the measures. And again, as I said, there should be appellate courts reviewing sentences.
Go here and then come to Joe.
Mr. Slotnick, I agree with your earlier statement about mandatory sentences. Yet, at the same time, I'm also pulled in the opposite direction by the benefits of a certain determinism to sentencing. In your opinion, do you think we could achieve this by perhaps controlling or even in some ways eliminating this certain litany of appeals that almost professional criminals have learned to gain an extended life by just riding the system out, knowing that they have, in a sense, a hidden advantage by playing on this continual appeal and appeal and appeal, until ultimately they can usually get off? Is this viable?
Well, I think constitutionally appeals are proper and necessary. Statutorily, they're proper and necessary. Criminal defendants, no matter who they are, have the right to ride the system. However, what's happening in this country, with the understanding that there is an enormous wave of crime, and when the professor talks about community control, there is no community control. There is criminal control. Fortunately, we haven't denigrated ourselves to the point where we allow our judges and our legislators to be blown up as they do in Colombia and other places. But you know what? That may not be far away. I think criminals have a right to ride the crest of the system, but then eventuality there is an ending. We have a new ingredient into the system. I now know that if a client of mine is convicted, that his chances for bail following conviction are very little, at least in the federal courts. So that has changed. Sometimes criminal defendants ride the crest while they're in jail. It's more often now than ever before.
But just to end up real quick, would you support a proposal that would perhaps eliminate endless appeals on individual evidence issues? In other words, would you support a measure whereby in a criminal case, all evidence and all germane facts of that case had to be brought out originally so that appeals could not be made on specific pieces of evidence following the original conviction or verdict against that defendant?
I think the Supreme Court's basically done what I agree with. I think what they've done is they've talked about the appeals, the finality of it, the collateral attack, and the finality of that. So there's just so much that you can appeal, and I don't think that criminal defendants get a great advantage out of appealing. I just think that they're exercising their rights under the law. You're not able to bring forward on collateral attack something that should have been brought forward on a direct appeal. And there is waiver, and there are other things. So I think there's an end to everything.
It really wasn't our plan to steal the thunder of the next panel. Joseph Rodas?
My concern is with the propriety of the Harris sentencing. And I believe your comment was that you felt the judge responded too much to public sentiment and that the sentence was possibly too harsh as a result of that response. And I wonder how that compares with the notion that a part of the purpose of punishment or sentencing is to satisfy the public's sense of justice, and that there's been a match between what was the crime that was committed and the punishment that's being given. And so doesn't that create a conflict perhaps between an elite sense of opinion that a sentence might be lighter and a broader public consensus that a sentence should be harsher? And how do you balance that out?
I think that quite clearly the community interest is very important, and the judge's got to balance that out and look at that. I believe that the community via the victim impact statement or the community via the media has an effect on judges. I have no problem with regard to that. I think that the judge, for example, in the Getz case, in giving him the sentence that he did, had a wrong perception of what the community wanted. In actuality, the community was aghast at the sentence, but it was this judge's perception that's what they wanted. So he was just not in tune with the community.
Court sort of depends on who you define as the community, because there were elements of the community. Elite opinion, I think, is what Joe was driving at there, that did agree with the time.
My question is to anyone on the panel that cares to address it. It seems as though that the concern that you evidence over the sentencing is really trying to resolve the frustrations which have been inflicted on the criminal justice system, which are really influencing the other processes. Specifically, if you break it up into three different segments, if someone has committed a crime, you have the probability that he's going to be caught. Given that he is caught, you have the probability he's going to be convicted, and given that he's convicted, the probability that he will receive a just and appropriate sentence. Would you agree that if we can raise the first two probabilities, i.e. that given the fact that he's committed a crime, the probability that he is caught is raised to an unacceptable limit for the criminal, and second of all, given that he is caught, the probability that he is going to be convicted is unacceptably high, can we not then allow greater flexibility in sentencing in order to resolve this dichotomy of the individuals who have committed crimes for entirely different reasons, which people inherently believe cry out for a different punishment?
Let Charles go first.
Yes, I want to demonstrate the fact I've actually done some work in this area. I was in Chicago some years ago dealing with chronic delinquents. evaluating program to deal with chronic delinquents. And I found, as one of the most interesting statistics we collected, that the youngster in Cook County, inner city Chicago, who was sent to an institution for the first time had 13.6 priors, average. And when you have that kind of situation, it doesn't make any difference how much you raise the probability of apprehension. And it doesn't make, I think, even that much difference how much you raise the probability of conviction. I'm talking about juveniles in this particular case. But what happens is, I think, in speaking from a sociological or psychological point of view, is you always think you can beat the rap. The system has become a game that you play, and there are all sorts of hidey holes that you can hope to take advantage of. And a great deal, I think, of what contributes to what I was calling the sense that we lack lawfulness is precisely that that's the way the system is perceived. Generally speaking, I think I would associate myself very strongly with what Ernest is saying for a variety of reasons, but not the least of which is that a major portion of justice has to do, I think, with predictability and consistency.
Right, but that's just my point. If you have someone who is engaged in 13 acts of criminal activity before he goes to an institution, if he disappeared after the second act, I would have to believe that based on his experience, based on his knowledge of what the effect of the justice system has been on both himself and his friends, there's not going to be somebody around who can say, hey, beat the rap 12 times.
Oh, but if he's sent the second time, doesn't, on the average, let's say, wouldn't that imply the kind of consistency and predictability I'm talking about, which wouldn't that also imply a lot less of the discretion at the end of the process?
No, whether he would be sentenced to 2 years or 20 years would be left up to the judge to determine that based on recidivist rates, whether or not he believed the individual would repeat, and so forth. But the key element here is, if you're going to raise it ideally to a certainty, that if he commits the crime, he will be caught, and if he is caught, he will be convicted. I would submit that given those two circumstances, you have much greater latitude in doling out punishment to fit the appropriate crime, because what you're really doing is you are convincing someone that he cannot escape the punishment.
Certainty as opposed to length.
But how would you accomplish this? No country in the world has the kind of apprehension rate that you envisage.
I agree.
We
what I'm saying is
convict
that
perhaps 3% of all those who commit index crimes. If we were to spend much more money and make efforts, etc., change the laws, we would convict 4%. I don't think what you have in mind is
we'll have to
no
continue.
country in the world convicts more than 4%.
We'll have to continue at the closing reception or something. We'll give these other folks a chance. Go ahead.
Okay, Dr. van den Haag, my question is, what respective emphasis should be given to retribution and deterrence in fashioning the scope of a particular criminal prohibition? For instance, if we wish to deter murder, we can prohibit gun ownership, or we can more narrowly circumscribe the prohibition to prohibit murder. And in one case where you're prohibiting gun ownership, it seems to me you're emphasizing the deterrent rationale, and for the reason that all gun ownership it seems to me, isn't inherently wrongful or immoral. And I'm wondering whether you think it's an ideal of the criminal justice system to tailor the criminal prohibition to the specific evil that you wish to deter or do retribution for.
Well, I'm not sure I understood your question fully, but to prohibit gun ownership has nothing to do with deterrence. It has to do with prevention. And I incidentally think it's a wrong measure of prevention. I'm all in favor of gun ownership. I don't find anything inherently wrong in it. Now, as for you, the second part of your question, how to reconcile sentencing in terms of the deterrent effect desired and in terms of the justice of the sentencing, it's fairly easy. We can, at least in principle, establish what deterrent effect a given kind of sentence has. We generally seem to feel that 10 years deters more than 5. We have no real evidence along those lines, but I think that could be fairly easily determined. And I think it's a common sense experience that all other things equal, a more severe sentence is likely to deter more than a less severe sentence. Now, is it just? Well, on this one, we don't have to worry too much, because nobody can determine what sentences are just, as I spent some time trying to explain. There is nothing that tells us, given the gravity of the crime, what the right sentence would be for that. We do that simply by tradition. So therefore, you might just as well say that which deters seems to me right. There's one exception that I should mention. We do sentence particularly severely for crimes that probably are non-deterrable and where deterrence probably should play no role, certain kinds of murder, for instance. And that is simply because the sentence not only is meant to deter, but is also meant to express the outrage of the community. I don't see any great difficulty in combining this.
Okay. Thank you. We've got 2 people left. Nobody else get in line. We'll let these gentlemen finish it.
Yeah, this is for Mr. Slotnick. It seems like one of the reasons so many people here have reservations about indeterminate sentencing is because they think the judges are weirdos. I mean, they're basically a bunch of rich lawyers. They have a highly idiosyncratic perspective just from being in the legal subculture. Why not just leave sentencing to juries?
I've always felt that perspective. I've never had the nerve to write it, but to be quite candid with you, if the case does go to trial, I have no problem with leaving sentencing to juries. I think that they get a better perspective of what's going on, and I think they can pass it along. I also believe, by the way, that they have to be monitored by ultimately the judge. We have to have some sense and belief that our judiciary functions and works properly. Now, I will tell you very quickly, in New York, for example, if he were to be found guilty, Carl Rowan would spend the next year writing his columns in jail. I don't think a jury would do that to him, and nor do I think if there were indeterminate sentencings with regard to gun laws in New York, that would happen to him. And that's why I think it's dangerous. No matter where we stand, I don't want to see Carl Rowan in jail for what he's done.
Last question.
My question is for Mr. Murray. You made the observation in your remarks that minor crimes receive minor punishments and more severe crimes receive more severe punishments. My question is, if the purpose of punishment simply to extract from the offender for society some sort of equitable compensation for what that person did, or if the purpose of punishment is to deter crime, to prevent crime, is it desirable to make punishments for even relatively minor crimes as severe as punishments for more severe crimes? An example would be, I have friends who lived in Saudi Arabia, and she says in this place people don't even bother to lock their doors because the penalty for petty theft is dismemberment. So.
It really does. One of the things that Ernest von Haag said in a previous lecture that has reverberated in my mind ever since, anytime I read an article about the drug problem, is that Professor von Haag said, listen, do you want to stop the drug problem? Don't go after the dealers, because even if you have capital punishment, that is not sufficient to deter people from taking a chance and making the enormous profits you get from dealing drugs. Go after the first-time offender and sock him with a jail sentence, because, and he makes the argument much more ably than I can, but they're very easily deterred. And I do not fault that kind of logic. I do not fault the effects in Saudi Arabia of dismemberment as a deterrence to robbery. But there you were talking about a utilitarian virtue of punishment as distinguished from the virtue I was talking about, which has to do with satisfying my sense that the world is a lawful place. And I would not necessarily rule out using punishment for utilitarian purposes. I guess my message was simply more directly that there are other things that validate punishment besides that.
Any closing comments from either of the other panelists? If not, I'd like to thank all three of them for a very invigorating discussion.